Hey guys, nobody's here yet, so I guess I will give it a few minutes. I am excited. Can't wait to see this. I waited to watch it with you guys, so this will be my honest first time reaction. Hey, Flash fan, I'm good. Uh oh, hang on. Whoops, forgot to mute my channel. Had it up in the background. Um, so this was Ashley Benefield's hearing about her lawyer did a motion to he wanted to interview the jurors because there was he felt some juror misconduct because a cell phone apparently was used in the juror room because somebody named that Hoodie Guy was posting updates, and it seemed to match up with what was actually happening in the jury room as far as what they were reporting to the courtroom as far as time-wise as decisions they were making. So it seemed like it was accurate. So there was a phone in the juror room. But then the guy said that his sister excuse me, the guy said that his sister was a juror. So, but he said it was a flip phone. Now, the flip phone that I had, the old flip phones, they did not have access to the internet. I don't know if this one did. And if it did, it doesn't mean that anybody connected to the internet and looked anything up or anything like that, which is why they need to interview the jurors. They can't just say, oh, it was juror misconduct because there was a phone in the juror room. So there are, on the clerk of court's website, there are 6 I just forgot the word, orders to appear to the 6 jury members, and the hearing where they are going to interview the jurors is on October 4th. So that's a week from this Friday, and it's going to be in camera. I don't know if they're going to do it the same way that they did this hearing. This hearing, it was not live streamed the day that it was done, which was very disappointing to me because I could not wait to see this. And then it was on Court TV, and it was members first for, I don't know, like 3 days maybe. And it was driving me crazy because I wanted to watch it so bad, but it was like, I cannot watch it because I know that I have people that want to watch it with me for the first time, and I can't do that to them. So I have been waiting to watch with you guys. So I'm so excited. So let's go ahead and get started. If I can find it. Why? Why, if it's in camera, would that mean that it's not open to the public? I would think that would mean that it was. I don't know.
Is this just the voir dire?
It's the entire first day.
First day. All right. Thank you.
All right, Your Honor, on behalf of Ms. Benefield, and and pursuant to our motion to interview the jurors, which a lot.
I don't know. I don't know if that means it's in the judge's chambers, but on camera in the judge's chambers or in camera in the courtroom, but they just take them like one at a time. Like they did when they interviewed the Murdoch jurors, or Murdoch, or however you say his name. I don't know. I guess I need to research that. My go-to lawyer just had a baby, so she's busy.
Lot of which was incorporated in our motion for new trial. First thing I want to address is the juror misconduct. The court has pretty much framed the parameters, and that the prosecutorial misconduct allegations are for another day, if at all. So for today, we're going to discuss what I've characterized as identifiable and unidentifiable juror misconduct. I think as it relates to identifiable juror misconduct, that term is being used and focused exclusively on juror number 15, that was Sarah Walcott. And I want to remind the court as I go through my argument that at the conclusion of jury selection, the defense still retained one peremptory challenge. Now, the most compelling evidence of identifiable juror misconduct as it relates to Ms. Walcott is the following. First thing I'd like to do, Your Honor, is supplement to our Exhibit E on our motion for new trial.
You're right, Flash. That sucks. In camera is not what it sounds like. In camera is a Latin term which literally translates to in chambers, but carries the meaning in private. Portions of a case held in camera are held in private before a judge where the press and the public are not allowed to take part. I thought in camera meant in camera, what it says, but no, of course not. It's law, so it has to be confusing. Well, dang it, that stinks. I'm sure, though, we'll be able to find out what the outcome of the interviews are. Dang it.
Or Exhibit B on a motion to interview jurors.
No camera.
I want to
In camera
supplement
means
it
no
with
camera.
a copy of Ms. Walcott's questionnaire. If I could have the clerk mark it. Does the court want a separate copy?
Yes, please.
Do you have a separate one?
Yes.
You have two.
I have copies for everybody.
And clarify again, you said this is an additional page to Exhibit B of the defendant's motion to interview jurors.
Yes, B for the motion to interview jurors and the E for the motion for new trial. And may I present a copy to the clerk for marking?
Yes.
The pineal gland has tiny little cilia,
Dang it.
hair-like extensions all around.
I am again, and I don't want to.
So,
Well,
the questionnaire,
I thought it meant in chambers,
Your
but I
Honor,
thought it meant
contains
camera, though.
a very obvious admonition that
Like
says,
on
under
camera.
penalties of perjury, I declare that I have read the foregoing jury questionnaire and swear or affirm that the facts stated in it are true. Now, one of those questions, as I've highlighted for the court and for the record, is, quote, have you or a member of your immediate family been?
This is about the other juror. So we had the phone issue with the juror, and then we had this juror that he says lied on the juror questionnaire about if you'd ever been a victim of a crime, or I think there's a question about DV, and she's got a past history of DV against her husband. She's had TPOs taken out against her by her ex-husband, as well as been a victim of it by her boyfriend, as well as her son doing it to his pregnant girlfriend, which I don't know. I don't think that applies, but so he is saying she lied on her jury form or juror form, whatever. And her attorney, I think, also appears in this hearing.
In unquote, victim of a crime. Ms. Walcott put an N in that block indicating no. We filed in our motion for new trial under Exhibit E, and in our motion to interview jurors, Judge Whyte, under Exhibit D, a domestic violence injunction petition filed by Sarah Walcott in case number 2016 DR 001301AX. The facts also include are that her then boyfriend, Albert Ballinger, was arrested on February 20th, 2016 for allegedly grabbing her hair by the back of her head and slapping her across the face 5 times. The deputies observed redness on the left side of Miss Walcott's face. Mr. Ballinger was arrested, and Miss Walcott filed a petition declaring herself to be a victim of that offense. That is in absolute and direct contradiction to the form that she
He has
signed.
an appellate attorney now that's co-counsel.
Additionally, Your Honor, during the voir dire portion of the trial, the following questions were asked. There's not a whole lot of relevant ones, but to set the stage for the court, before I read the exact questions, Ms. O'Donnell had asked about child custody matters, and I had asked about experience in the domestic violence courts. Here are the specific questions that were asked and the pages and lines where they appear. On page 233, Judge Whyte, line 9, Ms. O'Donnell asks, have any of you here ever had any dispute with your significant other about your child or the custody of your child? Additionally,
watch what avocado does to belly fat.
Fun fact, if you add avocado to a salad, you will
Ms. O'Donnell asks on page 234, line 23, has anyone here ever had like a heated custody battle with anyone? She then acknowledges another juror, 26, who raised their hand, and she goes throughout her voir dire very meticulously back and forth, each side of the courtroom, left and right. As the court knows, the jurors were numbered to a certain amount on the left side and then the remainder on the right side. Additionally, on page 236, line 17, Ms. O'Donnell is heard to say, and how about over here?
So you said 276?
236.
236.
Line 17.
Thank you.
If I'm going too fast, Judge, let me know. I'm sorry.
I'm just writing as fast as I can. Go ahead, sir.
On line 17, Ms. O'Donnell asks, and how about over here, indicating to the right side of the courtroom where Ms. Walcott is seated. There were several other people that raised their hand. Anyone that's had a contentious battle besides number 26 in the back over here? How about over here on this side, number 51? On the next page, 237, Judge Whyte, line 15, Ms. O'Donnell asks once again, and who else over here on this side? And she calls out juror number 62. On page 38, and this is still over child custody matters, page 238 on line 14, Ms. O'Donnell asks, okay, someone else raised their paddle. 38, and you had a custody dispute with your children? Prospective juror, 38, yes. And finally, on page 239, Ms. O'Donnell goes back to the other side once again. And on line 8, she asks, anyone else on this side of the room? Okay, no one else. Now, she finishes her voir dire and the court calls on me. And on page 283, Your Honor, line 19.
Yes, sir.
I asked the following question of the veneer. Has anybody in the prospective veneer been involved in domestic violence courts? There's a show of paddles. I follow that up by asking on page 284, line 8, how many of you know or have experienced an abusive male? And I might add that the court reporter, of course, is diligently noting the paddle numbers of the jurors that respond affirmatively, and the court will note juror 15 is not among them at any point. And the court report even goes so far as to say on line 22 of the same page, 284, court reporter, wait a second, I need your paddles, don't just yell out. Now let's look at what the evidence is that we produced for the court in light of those voir dire inquiries. Well, first, we provided, Your Honor, with Exhibit G to the motion to new trial, or alternatively, Judge Whyte Exhibit E for the motion to interview jurors. We provided the court with a domestic violence injunction where Sarah Walcott was the respondent, the person that it was filed against. It was by her ex-husband. The case number is 2003 DR 4890. This was a domestic violence injunction filed and sought by her ex-husband, Charles Walcott, on behalf of their minor son, Hayden Walcott. The ex-husband sought custody of the minor son. The petition was ultimately dismissed, but for our purposes, that's completely irrelevant as it was filed against Ms. Walcott. In case that's not enough, Your Honor, as Exhibit H to our motion to new trial, which was Exhibit F to our motion to interview jurors, we attached another domestic violence petition filed against Sarah Walcott, case number 2004 DR 002205. It was an injunction once again sought by her ex-husband, Charles Walcott, once again on behalf of their minor child, Hayden. In this instance, the court issued a temporary injunction to Mr. Walcott, and Mr. Walcott sought and was granted temporary custody of the minor child, Hayden Walcott. Mr. Walcott's accusations in that petition alleged child abuse against Sarah Walcott, and specifically stated that Sarah Walcott, quote, picked up the minor, Hayden, by the arms and slammed him against the wall. The significance of that, of course, Judge Whyte, is that Ashley Benefield made child abuse allegations against Douglas Benefield. And I assure you, especially given the voir dire that the court conducted, we took several hours that the court patiently went through all prospective jurors that were subject to cause challenges. I have a very high degree of confidence had this information been revealed, Ms. Walcott would have gone out on a cause challenge, and I don't think that the state would have objected to it. However, that too is really irrelevant because the defense had a peremptory challenge that remained, and I can tell you unequivocally, we would have excused Ms. Walcott had it been disclosed. Additionally, Your Honor, Hayden Walcott, again, this goes to the voir dire question about how any of you been involved in the domestic violence courts, and the court may recall that the petition, the questionnaire rather, that Ms. Walcott executed says her or her immediate family, which would include her child, Hayden Walcott. We attached as Exhibit F to our motion for new trial, which is also Exhibit C, as in cat, to our motion to interview jurors, an aggravated battery charge against a pregnant victim, case number 2014.
Yeah, but that was her
CS
son doing it. I don't.
3121 against
How's
Hayden
that-
Walcott. She was the victim, Mr. Hayden
Does that
Walcott's
make a
live-in girlfriend.
difference?
He appeared on the scene heavily
Oh.
intoxicated, and Sarah Walcott posted the cash bond for him to be released. Once again,
Okay, yeah, I
despite
guess
the
that's
question
why
about
then.
domestic violence, no disclosure. And finally, Your Honor, again, as it relates to the voir dire, in a bar fight charged with felony battery on June 1st, 2024. This would have been right prior to us selecting the jury and the trial commencing. In Manatee County Sheriff's Office, arrest number 2024-012314, which I would also at this time ask that the clerk mark as a supplement to our exhibit F to our motion for new trial and mark it as F2.
Old skin versus young skin.
The kids on TikTok say this is good for smile lines. I don't think so. See,
Any objection? State.
Relevance, first of all, I don't know what it is. First time I've seen it.
It's the arrest affidavit that they paid more on for what I just stated.
I don't know how that's relevant.
All right, so there's no objection is relevance. Any other objections? Go ahead. Overruled. So
Mark a copy to
Mark that as
to exhibit F of our motion. for trial.
F2. F2. All right, yes, sir.
I don't think I've ever disliked a prosecutor as much as I dislike that
This is a
woman.
bar fight on June 1st, 24, where Mr. Hayden Walcott is observed on video, according to the deputy, punching the victim in the face with, quote, significant force, once again, not disclosed in voir dire of the questioning of Ms. Walcott about abusive males or domestic violence. The second part of our presentation, Judge Whyte, goes to the unidentifiable juror misconduct. And that is where we have a witness standing by to testify. I'll go through it if the court likes, and then I would like to call the witness, but of course that'll be up to Your Honor. So this is what happened. If the court recalls, on the evening of the verdict, the first thing that occurred was a question from the jurors about whether or not Dr. Quintel's conclusions about Doug Benefield being A, super controlling, B, a real alpha male, and 3, having an issue with intimidation, was Dr. Quintel's conclusion or based upon information that Ashley provided to him. At the time they asked the question, I took the position, believing it to be pretty simple, that a readback of Dr. Quintel's testimony would quickly put an end to that consideration, because my question to him was, did you, Dr. Quintel, as an expert trauma specialist, reach any conclusions as it related to Douglas Benefield? There was a dispute with the court about whether or not the jury knew that they could ask for a readback, but what then followed, Your Honor, was a really puzzling and very alarming recitation of events on a public website by law and crime networks called Verdict Watch. We were able to capture it before it was taken down, and it was taken down pretty soon after it was posted. But there was an individual by the name of that Hoodie Guy. And what was so alarming about this was that everything that the Hoodie Guy reported came to pass exactly as he reported it, but a couple of minutes later by the jury. So, for example, at 10:20 p.m., 10 minutes before the parties were notified that a verdict had been reached, the Hoodie Guy posted a comment stating, "Verdict incoming." That's Exhibit A1 to our motion for new trial.
All right, I'm looking directly at that. I'm looking at motion to interview jurors. I'm looking at defense exhibit A1, first page of that.
On the motion for new trial. I'm going back and forth between the motion for new trial and the request to interview.
All right, then is the exhibit in the motion for new trial different than the motion to interview jurors? Because I'm looking at A1 from the motion to interview jurors. It says exactly what you just said.
I believe we repeated it. Let me just do a real quick check here. Yes. These are the actual screenshots in the motion to interview jurors that we provided for the court. The summation that I'm giving the court is coming from page 23 of our motion for new trial.
Okay, so my question is, both on page 23 of 26 of the motion for new trial, and today during your oral argument, you've referenced verdict incoming as being at 10:20 p.m. The what I've been provided doesn't have a timestamp. How are you able to make that assertion?
I believe we made that assertion by virtue of preserving and noting as it was taking place what was happening. That's one of the reasons why we have the witness standing by.
Okay.
All right. So the second thing that happens, the that at 10:25 p.m., moments before the jury comes in, that Hoodie Guy posted a comment stating, quote, per sources, 5-1 guilty with the man stuck on not guilty or manslaughter. Now, the court may recall that following that first question and the dispute about the readback, the court told them rely on your recollection and sent them back out. They returned shortly thereafter and said that they were hung. This was what was posted as a result. The next thing that's posted at 10:27 p.m., according to that Hoodie Guy, is a comment stating, my sister snuck a flip phone in. That's Exhibit A3. At 10:28, Your Honor, that Hoodie Guy posted a comment stating,
Why would
I
somebody
am the
do that?
brother of one of the jurors. She just texted me this. Per sources, 5-1 guilty with the man stuck on not guilty or manslaughter.
And if that was my brother, I would
Exhibit
kill
A4.
him.
At 10:28, that Hoodie Guy posted a comment stating, my sister snuck a flip phone in. She texted me 5-1 guilty, may compromise on manslaughter. And at 10:30 p.m., the jury comes in and announces they have a verdict of manslaughter. And that was a mere 2 minutes after the Hoodie Guy posted what he did.
It's hard to feel like I'm the
I will defer to Mr. Pinnell and any discussion the court wishes to have with him about juror interviews and what the rule says. But I would remind the court that the standard in the rule is not very high. It requires reasonable basis to believe that the verdict may be subject to attack. And if so, if that is shown, the court does not have discretion according to the rule. The rule says the court shall order an interview. And of course, that's the whole purpose of the interview. It would be to discuss whether or not something like this in fact took place. I further tell the court that as it relates to Sarah Walcott's falsification of the questionnaire and refusal to disclose on voir dire the independent evidence that we've discussed here today, I do not see respectfully any way that the court's going to be able to get around that. That is misconduct proven beyond any doubt. And you can try to parse the question, have you been involved in the domestic violence courts any way you like? But I don't think you'll be able to do it in such a manner as to eliminate the fact that you had not one, but 2 domestic violence petitions filed against you, which you did not disclose, and that your husband sought custody of your minor child, and you did not disclose that either in response to the state attorney's question. With the court's permission, I'd like to call Ashley Boyer now to testify to the...
Judge, and I'm going to object. I have not been notified of any witness. They have not listed any witness. I have no idea who this witness is. Their discovery obligations are to tell me who their witnesses are, so I have the opportunity to know who they are before they call them. So I don't even know who this person is.
This is a person who approached us after the verdict or immediately before the verdict to show us pictures of what was being posted on the Law and
You
Crime
know
Network's
what,
verdict site.
Suzanne? You
And,
don't play
told us
fair.
that she thought
So
initially that it was just
he
some
shouldn't
troll,
have to play fair.
that was looking
either.
to inject themselves into the proceedings. But when she noticed the timing and the subsequent verification, if you will, by the jury's actions, she brought it to our attention because she was concerned. She is independent. She's not affiliated with the defense in any way.
Has she been disclosed?
We haven't had a discovery request for this hearing, Your Honor.
So, the state has to ask for that information?
No, we haven't. We never received it.
So has there been a disclosure pursuant to the rules? You have to list, well, you know what?
Yeah.
All right, so no.
In addition, we did not know if the court was going to actually take testimony here today.
So don't disclose her unless I decide to listen, hear her, and then disclose her.
No.
Okay. And you want her to present testimony remotely?
Yes, she's
Have you filed a motion under Rule 3.116?
she's about 9 months pregnant, Your Honor. No.
Okay, all right, then I mean, the rules are clear. Now, I'm confused. Was that the opening, and then you're going to do the closing?
No,
I was just going to
that's-
discuss. I was going to discuss the rule and the case law.
All right.
That's our motion.
Just
Do you have anything else you want to say, and then I'm going to go to the state?
Yeah, I have one other request for the court. We're under the impression, Your Honor, that there is court security footage, video that's maintained. If there is, we'd like to make a request that it be preserved because we think it may show Ms. Walcott and whether or not she responded in any capacity. Trying to give the court reporter the benefit of the doubt that maybe she missed Ms. Walcott holding up a paddle to any of these things. So to the extent there is such footage, in the interest of justice, we would like Your Honor to take steps to preserve it. Mr. Pinnell will address with the court any questions of law that
You know, I just said she doesn't play fair, so he shouldn't have to either, which is wrong. Because there are rules that he has to go by, but he screwed up again. I don't know why he keeps screwing up, like with the DNA analysis. Now, like, he couldn't use the DNA because he didn't get the person that tested the DNA on the stand. And I remember telling Alita, I told Legal Bites, I said he messed up because he didn't get the right person on the stand to let in the DNA. And Alita said, well, yeah, but it wouldn't have really mattered either way because they were there, they were moving, they were touching boxes, they were touching things, packing boxes, touching, like not touching each other, but bumping into each other. They were touching objects, handing objects to each other and everything. So the fact that he grabbed her arm when she was trying to get out the door, his DNA was all over the place. Her DNA was all over the place. It wouldn't have mattered. So she's right about that. But still, I was right that he didn't go through the proper procedures to get the DNA admitted into the trial. So even though it wouldn't have made a difference, he still didn't go through the proper procedures. And he just did it again. And this is even more important because he could use this to get her a whole brand new trial. And he wants to skip steps. And during the trial, I do remember they said that this is the first time this attorney has ever been before this judge before. Maybe he has been in front of other judges that have allowed him to skip steps, and he's gotten used to doing it that way. But he needs to tighten the reins a little bit because this judge isn't having it.
The court has.
All right, I am not the custodian of the information that you're referencing.
I understand, but I think if the court asks that it be preserved, I have a high degree of confidence that it will be. Is that acceptable to Your Honor?
Sir, I'm not the custodian. If you want to file a motion, I guess we can have the parties here, we can be heard on it, but I'm not the custodian of those records. State.
First, Judge, I would object to the lawyers tag teaming with their arguments. This is one lawyer can do these arguments, whether it's factual or legal. That being said, I first want to address the paddle issue. The representation that Mr. Taylor has made about what happened in jury selection with those paddles is completely and 100% inaccurate. When those questions are asked, paddles are raised. The court reporter does not write down the number of every paddle that was raised. Not once have I ever seen in a transcript that the court reporter tries to write down 30 different paddle numbers as to who raised their paddles. I cited in my motion 2 different places where I asked very specific questions, and I started asking questions in response to that. I can represent to the court that I almost never go to every single person that raises their paddle. That is a habit of mine. I don't go to every person that raises their paddle. So to make the assumption that someone did not raise their paddle based on the fact that I did not speak to them, I think is completely improper. And I also believe that the defense asking the question, has anyone had any contact with domestic violence courts?
The best way to burn fat and get shredded is not keto, it's not paleo, it's not vegan.
He says in his response 2, which I'm assuming means he saw 2 people raise their paddles. Nowhere in that transcript does anyone say what numbers raised their paddles. It is quite possible that Ms. Walcott did raise her paddle, and we are sitting here maligning her, acting like she withheld this information inappropriately, which I find highly objectionable. And the rules for this sort of thing, interviewing jurors, yes, jurors can be interviewed, but what Mr. Taylor did not mention is how strict the standard is in order to get to the point where you interview a juror because of public policy reasons. Because how are we ever going to get jurors to come in here if they know that after the fact, someone is going to dig into every aspect of their life and call them liars when they didn't lie and distort the record to meet their own needs? There has to be a line drawn. And I would like to bring the court's attention to, it's in my motion, but I'll state it just briefly. The case of Baptist Hospital, which is cited in my motion, and also the case of State versus Hamilton, which I believe defense also just provided. It says, when you're talking about juror non-disclosure, however, in the light of strong public policy considerations, Florida law only allows juror interviews in limited circumstances where the moving party has made sworn allegations that, if true, would require the court to order a new trial because the alleged error was so fundamental and so prejudicial as to vitiate the entire proceeding. And additionally, in Hamilton, it says, when a defense or the proponent of this fails to allege facts establishing a prima facie argument for prejudice, they do not get to interview jurors. And it is the state's argument that the defense has not provided prima facie evidence of this. The defense is saying lots and lots of terms and commingling. There's victim of a crime, charged with a crime, custody battle, injunction, and I think it's all getting blurred together. So if you go by exactly what the defense is saying that juror 15 did, the first thing is that she allegedly was intentionally not disclosing that she was a victim of domestic violence. And using the questionnaire where it says, have you or a member of your immediate family been the victim of a crime? Yes or no? And it is checked no. There is no evidence of any intentional deception. There are very, very different definitions of the word victim. Is it a victim in an injunction? Is it a victim in a crime where someone is arrested? How about if you're a victim and someone is not arrested? How about if you're a victim and the police come out and they don't even file charges? So that's why it is incumbent upon the attorneys to ask these questions, is to clarify, because not every person answers these questions appropriately because they don't understand what exactly legally is meant by these. Additionally, how many times have we gotten questionnaires that have absolutely nothing checked on them? Would that mean that they're lying as well? That's why I believe you cannot rely solely on a questionnaire. You have to delve into it. And the record itself, the transcript that you have, shows that the defense did not delve into this appropriately. Because even when he saw paddles raised, he did not go to those people that raised their paddles. So if he had exercised his own due diligence, perhaps could have found out this information and found out why Juror 15 maybe misunderstood or mischecked this box. But to insinuate that this person was lying on purpose is quite frankly offensive. And I do not believe that we can attribute that to her just based on a written questionnaire when the attorneys did not follow up appropriately one way or another.
Why did you tell me to
Also, the fact that she was a victim of domestic violence, according to the standard for non-disclosure.
I'm gonna kill you, Flash. Why did you have me look? Why did you have me look that up right now? Okay, Dr. Michael Birkland. Okay, this is the expert that's supposed to testify in Sarah Boone's trial. Dr. Michael Birkland, former medical examiner, arrested for storing human body parts in Florida storage unit in 2012. Is this the same guy? Are you serious? Oh my God. Okay, back to our regularly scheduled program. Oh my God.
The defense has to show that it was material to the jury service and that it was prejudicial. So how is the fact that this juror may have been the victim of a domestic violence situation prejudicial to a person who's claiming they were the victim of a domestic violence situation? So quite frankly, it's to the contrary. I would think that a juror that was misrepresenting or that was a victim of domestic violence would be sympathetic to a defendant who said, I was the victim of domestic violence. So in that regard, the defense cannot show any prima facie case or showing of prejudice.
While you are busy scrolling, you can spend a few seconds to help us.
Then the defense in the written motion talks about the son was the defendant in a domestic, and then also now somehow the son's a defendant in a bar fight. I'm a bit flabbergasted as to how this even is relevant that he was in a bar fight. I don't recall anyone being asked if anyone had ever been in a bar fight, but the questionnaire says, have you or a member of your immediate family been charged with a crime? And she did answer yes. So I'm not sure where the son's charges fit into this, unless the defense attorney is trying to say that, have you been involved in domestic violence courts somehow encompasses the son being charged. But if it wasn't Juror 15's charge, then why would she answer that question in the affirmative? So I think it's blurring many, many lines together. But when you break it all down, she made no improper representation about her son. She never said anything improper. And none of the questions that were asked by the attorneys in the questioning pertain to anything like this. So the defense cannot show prejudice in that regard either. Then, Judge, there's the fact that she had these domestic violence injunctions. The defense in their motion says child custody / domestic violence / abuse matters. But there's no evidence in the transcript. If you get the opportunity to read the transcript, the state found several places and the defense talked about them. The state did ask, has anybody had a dispute about child custody? Never once did I state who raised their paddle, and I do not represent that I talked to everyone that raised their paddle. Again, I said, has anyone had a heated custody battle? Same thing. People raised their paddles. I spoke to a few of them, make no representation that I hit them all. Then the defense said, has anybody ever been involved in domestic violence courts? And that's when the two people raised their paddles, and then he moved on to a different question. So at least where it comes to that, I don't believe there was any misrepresentation at all, or that the defense can show that there was any misrepresentation. And the defense didn't follow up on any of those questions when he asked, has anybody been involved in domestic violence courts? If you read the transcript, he just moved on to another question. He did not follow up with those two people that raised their paddles. So as it applies to juror number 15, the state's argument is that the defense has not made a prima facie case of prejudice, or even in most of these, he hasn't even made a prima facie case that the information was withheld or that the juror was untruthful. Also, Judge, this trial lasted 7 business days. So that's 9 days with the weekend. This jury was picked on a Monday. This information was not written in a motion until well after the verdict. This is information that could have been gleaned from the defense, because clearly they got it from somewhere. They could have gleaned this information while the trial was still going on, while we still had alternate jurors here, while we could have asked Juror 15 these questions. But the defense waited until after the verdict did not go in their favor to then put forth all of this information, where we are in the position that we're in now. And I believe the case law is very clear that that is not what this was meant for. It was not meant for you to wait to the point where it's irreparable to bring it up. That it should be brought up as soon as someone has done their due diligence enough to find the information on their own. If the defense was going to research every juror, they could have done it during the 9 days that this case was pending while these jurors were still seated. As to what I call the second issue, the potential phone in the jury room, first of all, the comments that are attached to this do not have times on them. It says how long the verdict clock. It may be incorrect, but some of the ones I'm looking at do not have times on. It just says verdict clock 6, like for instance, I'm looking at Exhibit A-5, and it says verdict clock 6:18.
If the court looks at the bottom right-hand corner, next to the white space bar on the bottom, it's a clock. And that's where the time stuff goes.
Okay, I can't read that. So if it's on there, is it here? With the little in the red?
Space. It's a different clock.
Okay, I can't see it. But the thing is, you can play these messages at any time. Anyway, Judge, I do believe that there is some discrepancy about exactly when these comments were coming in, but it is also the state's argument that this is an anonymous source. And we know from the law and how we deal with anonymous sources, they are given the very least amount of credibility. They are not to be believed solely on their own. So we should not give this anonymous source any more deference than we would give any other anonymous source in the legal system. One of the things that is internally inconsistent is that this person is apparently saying his sister is on the jury. And his sister has a flip phone, his sister's giving information. But the comment that says, this is what she just texted me, and then he gives like a colon, per sources, 5-1 guilty. Why would a juror say per sources? A juror would just say, we're saying 5-1. They would not say per sources. That indicates to me that whoever this hoodie person is, if they are getting the information, is getting it from someone other than a juror, not someone that's on the jury, because why would someone on the jury say it like that? Additionally, the court gave instructions to the jury all throughout the trial, all throughout every break that we ever took. You inquired to them after they came back from every break, have you gotten any information from anyone? Have you heard about the case? You know, whatever those specific questions were. And the jury indicated negative each time. The jury never any time during when they were deliberating or any time thereafter said anything to the court that they had information that someone was acting inappropriately or someone had a phone or something like that. They never said anything to you, even though for days and days and days, they knew you were asking this question every single time.
Hey, everyone. So the team decided to do a fun competition. If you're able to make a donation,
Go away, woman.
Also, Judge, even if you do take that this person somehow had a flip phone in the jury room, there is no indication that there's anything other than outgoing texts, even if there is, which I don't think there was, but even if there is, these are outgoing messages. There is absolutely no evidence or even indication that there was anything incoming that would have tainted this jury. And I would like to read from, it's my motion, and it's quoting the Mailer case, M-A-L-E-R, that I cited in my motion. In order to constitute juror misconduct sufficient to allow post-trial jury inquiry, the objective act must have been committed by a juror which compromised the integrity of the fact-finding process. And then there are examples listed in this case. And some of the examples are, a juror was approached by a party, his agent or attorneys, witnesses or others conversed about the facts and merits of the case in the presence of the jurors. Number 3, the verdict was determined by aggregation and average or by lot, game, or chance, or was other improper manner. Number 4, a jury went to the scene and reported its observations to the rest of the jurors. Number 5, a juror had a personal knowledge of the case and conveyed this knowledge to the jury. Those types of things are listed in the case as being objective acts which compromise the integrity of the verdict. Some anonymous post that we have absolutely no evidence of where it came from, it is more likely than not that this person got the information from some of the press people running around, or maybe court personnel that might have known something was going to happen. There's no indication that this was from inside the jury room. There's no indication that it was anything other than somebody posting on social media trying to get attention. And for us to inconvenience these 6 jurors in this manner, in this contentious case, in this way, it's quite frankly not appropriate. And this defense has not produced the minimum prima facie evidence in order to get an interview of the juror. So we would ask you to deny the request.
Thank you.
Can I make a big argument? Go ahead.
I don't mind if one of you wants to take the first part of a closing or argument and the other takes the second part, but I don't disagree. It's one or the other. Mr. Taylor, if you want to stand up and you want to address the court for your rebuttal, I'm happy to hear it. If it's going to be Mr. I'm sorry, again.
Pinnell.
Pinnell.
Refer to Mr. Pinnell, Your Honor.
May I approach the case law?
Yes, or hand it to the deputy. Sure.
Your Honor, I don't want to waste time on platitudes, but everybody in this court knows that the jury system is based on their jurors being honest and forthcoming and giving correct answers, whether they're intentionally correct or incorrect. Doesn't really matter whether they're intentional or not. It just matters whether they're accurate. The state alleges that the motion should have been filed sooner. The rule says it has to be filed within 10 days of the verdict. It's clearly filed within 10 days of the verdict. The idea that Mr. Taylor was supposed to research the jurors while he was busy defending his client, I don't think is a fair assertion. He had plenty to do representing his client in a murder case. The state raises a lot of good questions about what we don't know. And what I would suggest is they've actually proved the point. We don't know a lot of information, and the reason, and that gives us a reason to interview the jurors. As Mr. Taylor said, the rule does not, although juror interviews are disfavored, the rule has a pretty low bar. It says a party who has reason to believe that the verdict may be subject to legal challenge. And it says the motion shall state the name of any juror to be interviewed and the reasons the party has to believe the verdict may be subject to challenge. And upon a finding that the verdict, quote, may be subject to challenge, not definitely, not 80%, may be subject to challenge, a juror interview shall be ordered. I respectfully to the court, as an officer of the court, I don't think this is a close call. I think there's significant evidence that juror 15 either intentionally or unintentionally did not provide a full disclosure to the questionnaire and to the voir dire questions. What we haven't heard from the state is any allegation that they recall or saw juror 15 raise her paddle and Mr. Taylor not question her. I'm assuming as officers of the court, had they seen that, they would have told you that today. Mr. Taylor's sworn motion says, based on his recall and his notes, that he does not believe juror 15 ever raised her paddle, and that's the evidence that she didn't give a full disclosure. And we're here today to determine whether we get an interview, not whether we get a new trial. And so I do think the state is blending those two together as well. We're not at the point where the court is in a position to decide whether we're entitled to a new trial. We're at the point where the court is in a position to determine whether we're entitled to a juror interview. And I think, again, the evidence that's been presented easily meets that standard. I point the court to the Uther case, and it's Huether versus Barani. This is a 50 CA case from August 20th of this year.
I wish I would have known about the farmer's dog a lot sooner.
Are you serious?
And on page 2, if you're using the bottom right-hand corner, there's a statement that initially we note that Florida law has long recognized that post-verdict juror interviews are strongly disfavored and should be rare. But then they say on page 3.
You're talking printed page 3.
Correct.
Okay.
But then in the second full paragraph in the left column on page 3, it says further, even though Florida law rightly makes post-verdict juror interviews rare, where adequate proof suggests that a juror has acted improperly and contrary to lawful instructions of the trial court, an interview of the offending juror is appropriate. Then in the indented quote on page 3 in the right-hand column, it says it is the duty of the juror to make full and truthful answers to such questions as are asked him. A juror who falsely misrepresents his interest or situation or conceals a material fact relevant to the controversy is guilty of misconduct, and such misconduct is prejudicial to the party for it impairs his right to challenge. Lawyers representing clients in litigation are entitled to ask and retrieve truthful and complete responses to the relevant questions which they pose to prospective jurors. They are entitled to evaluate this information in determining whether to seek to excuse prospective jurors on peremptory challenge or for cause. So that's what happened in this case. At least preliminarily, the defense has made a showing that juror 15 did not disclose her involvement in domestic violence courts. She was involved both as a petitioner and a respondent. She made an allegation that she was the victim of domestic violence. I understand the state's argument that there's different definitions of victim, and I think that's why we get to ask her questions about it in a juror interview. But this case, this Huether case, is a case where the judge denied or granted juror interviews based on a failure to disclose information, and the opposing party sought to file a cert petition to preclude those interviews, and the 50 CA said the interviews were appropriate. And in explaining their decision at the bottom of page 3, it appears quite possible that JL concealed material information from the court and counsel. So they just say it was possible. Based on the allegations of the party in that case, it was possible, and they found that was enough to justify a jury interview. And then they cite favorably in footnote 6, this is on page 4, Before a party to a lawsuit should be denied the benefit of a favorable verdict and forced to endure the time and expense based of a new trial based on juror misconduct, the trial court should at a minimum interview the juror with the attorneys present and then make a finding of whether the contact was intentional and whether any party was prejudiced. So they're saying that before we move on to an appeal or a new trial, we need to be careful and interview the juror when there's prima facie evidence of the failure to disclose relevant information. Certainly based on the allegations and the facts of this case, whether an individual was the victim of a crime, the victim of domestic violence, the perpetrator of domestic violence would be relevant to whether the defense would seek to excuse her for cause or based on a peremptory. Mr. Taylor has stated under oath and up today that had he been provided this information, he would have excused juror 15. The Hillsborough case, 4th DCA, 2013, under head note 3, it says a juror's non-disclosure of information need not be intentional to constitute concealment in context of a motion for new trial premised on that disclosure. So the state spent a while talking about maybe the juror didn't understand, and that's fine. Maybe the juror didn't understand, but if the information is incorrect, it's incorrect, and it's a basis for new trial. And that's another case where the DCA said that there was reasonable grounds existed for a juror interview. It's our position with regard to juror 15, the wealth of evidence that the defense has presented easily meets the burden of proof under 3.575, and that the court should grant an interview where she is asked to confirm whether she was the petitioner in those particular petitions, whether she was a respondent in those particular cases, and whether she was a victim of a crime. And that would then conclusively establish for the court whether the information she gave was complete and accurate.
So those are the questions you believe would be asked at the hearing. Were you the petitioner? Have you ever been the petitioner of a domestic violence injunction? Have you ever been the respondent of a domestic violence injunction? Have you ever been the victim of a crime, a domestic violence crime? Is that it?
Those are the first three I could think of. I think there could be a couple more, but that would be the general context of the question.
That's what I guess I'm asking is, how deep does this go? Is it then digging down into the specifics and here's a police report and it says that this happened and this happened?
I agree with you. I don't think that would be necessary. I think those first three questions, without thinking it through, I could probably think of one or two more questions, but I think the court's concern is consistent with the case law that it's not supposed to go that deep. All we need to do is establish that it was not accurate at the time the statement was given, or when she failed to raise her paddle, or when she answered the questionnaire. So I agree with the court that it would have to go into more details. It would be limited to that general subject matter, and then we'd be able to make argument whether that was prejudicial.
All right, thank you, sir.
As it relates to the cell phone,
can you feel it? The balance of nature.
It's clearly against the rules for a juror to bring a cell phone into deliberations. We don't know today whether that happened for sure, but I suggest that we have strong circumstantial evidence, and I know the state stands up all the time and tells you that strong circumstantial evidence is as good as direct evidence, that there was a cell phone in the jury room, or at least a reasonable basis to question that under the rule. The YouTube user, that Hoodie Guy, said there's a jury, my sister snuck a phone into the room. So the idea that there's no evidence is not true. And then the timing lines up just too accurately for it to be a coincidence. The state is speculating that they may have heard it from a reporter, they may have heard it from someone else. Maybe that's true, but that's why we get to ask the jurors the questions about it. And I'd cite two cases: the Needleman case, where a juror did outside research and discussed it in the jury room regarding the definition of bribery and the penalty for bribery. And then the Tapanese case, TAPNES 4th DCA, there a smartphone was taken into a jury room, and it says juror misconduct gives to her a rebuttable presumption of prejudice. So just the phone being in the room is misconduct, but then we get to argue whether there's prejudice. The timing involved and the sworn allegations made by Mr. Taylor and the attachments establish that there's a reasonable possibility that there's a cell phone in the jury room, and then there's a reasonable possibility that there are not only outgoing messages, but incoming messages that may have been shared with other members of the jury. And the problem with that is that's when we have juror misconduct, when there's outside information is used by the jurors in reaching a verdict. And so we think juror interviews of each juror in the case should be granted, and also on a limited basis. The first question to each juror would be, did you bring a cell phone into the deliberations? Did you see anybody else with a cell phone? Did you see anybody else leave the room and go in the bathroom and hear them talking on a cell phone? And if any of those answers are yes, then short follow-up, was any information shared with you from the information that was communicated on the cell phone? We don't get to ask, did they rely on it? We don't get to ask, for their cell phone number. We don't get to, expect their cell phone. We get to find out whether they saw a cell phone, they brought a cell phone into the room, or whether they saw anybody else, and whether that cell phone was used, or the information from the cell phone was used during the deliberations. I think it's limited to that, and that's consistent with the case law. It has to be limited. But then we get to decide if that bears any fruit and there was a something in there, then we get to argue whether there's prejudice.
Yeah, then we can get to those next steps. Yeah. I know you just came on, so you may have to ask Mr. Taylor to answer this. Do you know what efforts, if any, have been undertaken to this point to identify that hoodie guy? Again, if you need a minute, I know you just came on.
I do, but what I know is that they contacted the television station to try to get copies of the texts and emails online. I know the television station was a little bit unresponsive. Beyond that, I don't know what efforts have been made.
All right. Do you know?
Television station.
Shut down pretty decisively by the television station.
I don't have anything further. Those reasons we believe juror interviews on the first issue, juror 15 should be interviewed on a limited basis, I discussed, and on the second issue, each juror should be interviewed on a limited basis, I discussed.
All right. Thank you both very much. I'm going to just give you a ruling from the bench because both sides laid it out, I think, very well in your motions, the objection, the case law that was provided. And I will say, even though I had not received yet or reviewed the transcript of the jury selection, I just happened to be there the whole time and have a very firm remembrance of what happened. With that said, at this point, the only issue that is before me is whether to grant the interviews or not. I don't make findings of prejudice. I don't make findings of credibility. I'm not in any way interpreting the posts that appeared in Defense Exhibit A to the motion to interview jurors. I don't express any opinion or thoughts or make any findings regarding the answers given by Juror 15 during voir dire, the answers provided on the jury questionnaire. No findings. The only issue before me is whether to grant those interviews or not, and then, if so, to decide the process that we're going to follow during those interviews.
Toots, you got to hear about this thing. It's like having the eyes of a hawk in your pocket. So there's this gadget, right, developed for the U.S.
And
Have it sped up.
having reviewed the law,
More
not only the law that was obviously provided by the parties, but reviewing the rules and the case law that is applicable to interview jurors after a trial, it is extraordinary.
Whoops, I didn't mean to pause it.
There's no doubt that this is an extreme step. But at this point, there is sufficient evidence in front of me to grant the request for the interviews. The issue then becomes the process to follow to make that happen. Again, I think the issues of prejudice and whether anyone would have or would not have exercised a peremptory strike are for another day. So the issues I think we need to discuss are several, and I'm going to lay those out, and then I'm happy to hear briefly, and I say briefly because we were scheduled from 1:30 to 2:30, and there's some folks here that are waiting for their hearings. So I prepared to hear briefly on the following issues. Should this be in an open courtroom or in camera? As referenced by Judge Overton in one of the footnotes, which I had, and I appreciate you having that because there's two ways to do it. There's some case law you'll see out there where the court allows the parties to ask questions. And you'll see, of course, in Judge Overton, where he approved a process where the court asked questions. My thinking would be, if I am going to ask the questions, I'd certainly, you all could tender questions to me, and I could decide whether to ask them or not, and just see if it's error or not. And then how to bring the jurors that have been released by the court back before the court for interviews. Do they need to be subpoenaed, or is an order to appear sufficient? And an issue that came up today, and I will say that I think the cell phone issue, just so you have the benefit of my thoughts, the cell phone issue was certainly, factually speaking, I think more clear in my mind and towards granting the request for the interview. But as I heard the argument and considered everything today, I think the defense has made, I don't want to say a prima facie showing, but I'll use that word. I'll adopt the word you all used. A prima facie showing that you should be allowed to ask some questions and clarify from Juror 15. I do not at all disagree with the framework suggested by counsel, Mr. Pinnell, regarding those questions that I think are relevant and can be asked. And then it'd be up to the defense to argue how that would be prejudicial, and if it is prejudicial, and whatever other issues you need to argue. But what I had not necessarily thought about until it was brought up today is the issue that the jury questionnaires, this is not something we often think about when we're picking juries, are essentially, while not under oath, there is certainly a written, it reads very much similar to the written declaration in lieu of notary in chapter 92, 585. Don't quote me on that. I think it's 585, but it's somewhere around there. The written declaration in lieu of notary, and it does make me think that I should at least offer counsel to juror 15 and at least give her the option of that. So let's start with, it's your motion, so I'm going to start with you, defense. And again, when I say briefly, in camera or in the courtroom. And let me just say before we get into too far into this, I see this as a different issue than excluding a witness or a person from a courtroom. I think this is a different matter, so that's why I'm deciding whether in camera or open courtroom. Mr. Taylor.
My instinct and street sense tells me that we will probably get a more candid response if it is in camera rather than pressure of public.
I agree. All right, so they will be in camera. Where, I'll let you know specifically, whether we do it here and it's electronic or we do it in a jury room or one of the meeting rooms, I'll decide that. Because also, when we bring in the 6 jurors, because my intention would have to all of the 6 at the same time, but I'm going to put them in separate jury rooms to await the questioning, obviously, just in case you were wondering. Court or attorney questions?
Me again?
Yes, sir.
As much as I would like to question them myself, once again, I think perhaps the most candid circumstances would be most conducive to the court questioning, with the proviso that the parties get to submit potential questions to Your Honor, and with the further consideration that based upon what we might hear, that the court would give us an opportunity for a follow-up.
That sounds good.
Go ahead.
I would ask the court to do the questions, but I don't believe that there should be any follow-up.
What was the last part?
I don't believe there should be any follow-up.
Yeah.
Oh.
I don't mean follow-up by us, I mean follow-up by the
Right.
court.
So if you think about the scenario in trials where jury questions are allowed and the process we go through, that's what I'm envisioning. As I've said before, I have no problem taking good ideas from other areas of law and plagiarizing and using them. And I think that process, so my intention would be, if you all want to send forward some questions, that's absolutely fine. And those will be what I will work from. And as we go, depending on the information we receive, I may then send that juror out. You guys can pose additional questions to me and go that way. So that may take a little bit longer, but I think that'll be the most effective way to get all the information that both sides are trying to get. All right, so it'll be court questions. The next is how to summon them. I'll just say, I think an order to appear is sufficient. However, I wanted to give you the opportunity to make any arguments in case there was a position or some case law that I'm not familiar with that says once I discharge the juror, my efforts to issue an order to appear is a nullity.
I would suggest a phone call from the court's JA would do it, and I think that would be the least intrusive and the simplest. And in the event that one of the jurors rejects that, then I think we can address subsequent measures to the court. But I would guess a phone call from the JA requesting that they attend the proceeding would be sufficient.
I would defer to the court judge.
All right. I appreciate that. You would be shocked the number of people that don't respond. But with that said, I think I'm going to do an order for each juror to appear, each of the 6 jurors to appear on the date and time. So I'm going to have Kelly reach out and coordinate with the both of you to find a day at a time. There's 6 jurors. I would love to say 10 minutes each will be done exactly an hour, but I don't think that's realistic. So I'll probably ask her to block off 2 hours with you all.
We've got an incredible show for you tonight.
And this really, you don't have a dog in this fight. I think this is really more of a concern for the court. Does anybody want to be heard on the issue of Juror 15 and her order to appear having the offer of court-appointed counsel?
So I can only address this from my perspective as criminal defense attorney. If Ms. Walcott were, well, let's use a hypothetical. If somebody similarly situated as Ms. Walcott were to come to my office and I made arrangements to represent them, I would advise them to invoke their Fifth Amendment right to remain silent for 2 bases. One, potential perjury, and we can say, Suzanne can
But
stand
they're
up and
not
say,
under
"Look,
oath. Didn't he just say they weren't under oath?
A former juror, she may feel differently, or her office may feel differently in the event this results in a new trial. And secondly, I would advise my client to invoke the Fifth Amendment, Judge Whyte, based on the fact that as a result of her failure to respond properly to the voir dire questions, that she has exposed herself to direct criminal contempt by the court. And the court may very well have the authority to assess costs of that prior trial. So I think you'd be doing the right thing to advise her.
I'm just going to make the offer. Do you want to be heard?
No.
Okay. All right. So I'm going to advise Juror 15 that she's certainly entitled to hire an attorney, or the court will consider appointing an attorney to represent her if she financially qualifies. And then she can certainly make those arrangements through my office. We can put her in touch with who she needs to fill out that paperwork. All right. So with that said, I guess keep your phones on or your emails open. We'll be scheduling a 2-hour block. Send proposed questions if you want.
Can I just ask a question about the questions for juror 15? Are there some parameters that, I mean, what exact questions is the court looking for to accept?
I don't think it would be appropriate for me to give you that a preliminary ruling. I'm just saying submit what questions you want. I'll ask the questions I think are appropriate. There were some suggestions earlier by Mr. Pinnell that I think I spoke favorably of, but I'm not making any preliminary ruling. Submit what you want to ask.
And I guess my question is ultimately, can we have discussion if we do have an objection to a question, or is it the court's discretion?
I think it's ultimately my discretion.
Okay.
I think this falls squarely on my shoulders. I just want to give you all as much input and opportunity to be heard as I possibly can.
Okay.
All right. Thank you all very much. Thank you. I'll be issuing an order, but it'll be a very short written order.
Okay, yeah, I don't know if the judge wanted, if you wanted everyone to at least consider scheduling. We've got a lot of people in this mix, including 2 professional schedulers. So
I'm going to let you guys handle that with Kelly. I don't have days and times with me right now, but as I've said before, mornings, evenings, Saturdays, and Sundays, I will make myself available. You see the last because they know I'll be here on a Saturday or Sunday.
I have no doubt.
All right. Thank you all very much. I thank you for the very, very detailed, no, seriously, I'm not joking. The motions, the memos of law, the case law. Thank you very much. It gave me a lot to review before I came in.
Thank you.
Wow. You the whole thing. Wait. You mean the whole thing's getting dismissed, or just like that motion's getting dismissed? Because it's already been. It can't get dismissed because she's already been found guilty. I don't know. Oh, that's because I'm not talking into my mic. I don't know if she'll get a new trial. Someone got very angry with me because when I did the video about the motion for a new trial, I said that I didn't think the judge was going to grant a new trial. And I didn't give a reason. I just said because of the way he ruled during the trial. It's just a gut feeling because most of the arguments for a new trial was things that he said about the way the prosecution did the closing. And he didn't object at the time to the things that were said in the closing. And it's not considered good form to object during a closing argument, but it's allowed. And if they're making serious errors that could be a reason for a new trial, you need to object at the time because that could get your client convicted. And if you're not granted a new trial, your client's still convicted. So I don't know why he didn't object at the time, especially if they're saying things that weren't in evidence, because that's a big no-no. So yeah, I know. But now they're saying that Murdaugh might get a new trial. So I want to look at, there is one thing I don't think I have read yet, and that is the state's response. I might haven't forgotten, but I don't think I've read it yet. It is the state's response to the defense motion for new trial. The state of Florida, represented by Ed Brodsky, state attorney for the 12th Judicial Circuit of the state of Florida, files the state's response to defense motion for new trial and states, the defense motion outlines 8 alleged instances of prosecutorial misconduct in closing argument and claims that a new trial is warranted. Each will be addressed individually by the letter assigned in the defense motion. As an initial matter, the defense did not make contemporaneous objections to any of the alleged instances of misconduct, and therefore they were not preserved. Hang on. I gotta do something because I don't have. I need a second screen is what I need. That didn't do what I wanted it to do at all. The standard of review is therefore fundamental error. Robards v. State, Talley v. State. The court must conduct a two-part inquiry to determine if the closing comments amount to fundamental error. First, the court should determine if the comments were in fact impermissible. Second, if the comments were improper, the court must determine if they affected the validity of the trial such that, but for the comments, the jury could not have reached the verdict it did. False statements about Douglas Benefield filing for sole custody. The defense claims that the state's comment in closing argument was a comment on facts not in evidence. The state made this comment with a good faith belief that this testimony had come out at trial. As of this writing, the official transcript of the trial has not been completed, so this cannot be officially verified. Regardless, prior to closing arguments, the court instructed the jury with Florida Standard Jury Instruction 2.7, which in part says, please remember that what the attorneys say is not evidence of your instruction on the law. You still can't say facts not in evidence. This was an isolated comment by the prosecution, and thus, even if the comment were arguably improper, it was not of such a nature to affect the validity of the trial, such that, but for the comment, the jury could not have reached the verdict it did. I disagree. C. Improper attacks on and belittling of Miss Benefield's character and identity. The defense alleges that the state repeatedly and improperly attacked the defendant's character by calling her a manipulator. Not once did the state in its closing arguments call the defendant a manipulator or talk about her character. What? I forgot how many times they called her a manipulator. Not once did the state in its closing arguments call the defendant a manipulator. What? The state made permissible and reasonable inferences about the defendant's past behavior and her testimony during trial. An attorney is allowed to argue reasonable inferences from the evidence and to argue credibility of witnesses or a testifying defendant so long as the argument is based on evidence. Craig v. State. When counsel refers to a witness or a defendant as being a liar, and it is understood from the context that the charge is made with reference to testimony given by the person thus characterized, the prosecutor is merely submitting to the jury a conclusion that he is arguing can be drawn from the evidence. It was for the jury to decide what evidence and testimony was worthy of belief, and the prosecutor was merely submitting his view of the evidence to them for consideration. Yeah, but saying somebody lied and saying somebody manipulated are two different things. Based on the facts at trial and the defendant's trial testimony, it was proper for the state to argue that her behavior was manipulative, and therefore these statements were not impermissible. D. Improper speculation about out-of-court conversations. The defense alleges that the state's insinuation that Doug and Ashley Benefield were talking while they had a mutual injunction was improper. However, this comment is a reasonable inference based on the evidence that came out at trial and therefore was not impermissible. E. False claims about expert testimony. Again, the defense argues that the state's comment referenced facts that were not in evidence. However, Dr. Liu testified as an expert witness on behalf of the defense, and the defense asked in its closing why someone who worked and testified for the state for many years would testify for the defense, thus implying that this fact should add to the credibility of the defense case. This statement invited the state's response. It is common knowledge that some witnesses, especially expert witnesses, are paid for their testimony, and it was a possible explanation to the defense's question. The comment was an invited inference from the evidence and was not impermissible. All witnesses get paid, though. Even the state pays for their witnesses. That should never be mentioned. Although it often is, it never should. F. Improper appeals to emotion and sympathy. The defense alleges that the quoted statement in its motion is an improper appeal to emotion and sympathy. On the contrary, the statement was a recitation of the facts adduced. Is that a word? Adduced? Shouldn't that be deduced? I don't know. I gotta look that up. Facts adduced at trial and the reasonable and necessary standard in the justifiable use of deadly force instruction. The comment was not impermissible. Improper burden shifting. The defense alleges that by quoting portions of the justifiable use of deadly force instruction, that the state misstated the law and improperly shifted the burden. The state did not misstate the law orally and displayed PowerPoint slide track the jury instruction language exactly, asking a jury to decide if a person was reasonable and justified in using deadly force is not analogous to implying the defendant has the burden of proving such facts. The state did not misstate the law nor shift the burden to the defense, and therefore the comments were not impermissible. That one confuses me. It confused me when I read their motion for the new trial too, because I thought if you were claiming self-defense, that was the only time it shifted the burden to the defense to prove. I thought if it was self-defense that the defense had to prove that it was self-defense. Because I thought I heard one of the lawyers on YouTube say that if you claim self-defense, that you have to get on the stand and testify in order to claim self-defense. But maybe I misunderstood. E. Oh, this one's good. This is the one I have the most problem with because, like, she making up stuff about anatomy. She needs to go back to school. E. False representation of wound path. The defense alleges that the state misrepresented the wound path by contradicting the uncontroverted testimony. First, to say that the uncontroverted testimony was that the wound path was front to back is a misstatement of the testimony. Each witness indicated that the wound path was right to left and front to back. All of the experts, Dr. Vega, Dr. Liu, and Mr. Haig, were in agreement that the bullet traveled from the right nipple area to the left back area at a front to back angle. The images used in the state's closing arguments were created the night before closing arguments and were shown to the defense before closing arguments began. These images merely reflected the testimony of the experts. Since there was no misrepresentation, the comments were not impermissible. F. Cumulative effect. 6 of the 7 alleged improper comments were not impermissible, and 1 allegation has not been verified. Even assuming that the 1 comment about sole custody was impermissible, the defense did not make a contemporaneous objection, and the comment did not affect the validity of the trial, such that But for the comment, the jury could not have reached the verdict it did. This one isolated improper comment does not rise to the level of fundamental error. Suzanne O'Donnell. Oh, great. Oh, what did I do? Oh, hang on. Now I got everything all screwed up. Yeah, emotions are hard. Emotions were hard, and I'm not great at reading out loud. Yeah, he should have objected. And I don't know if it was because they were women, they came off like they were being mean girls. I don't know. They were just like, I don't know, they just seemed like bullies to me. And I went into this thinking she was guilty. But I watched her reaction to the 911 call, some of her reactions to parts of testimony, and then when she got on the stand. Those were the things, like her physical, and I'm not talking about tears, because I didn't see tears. I saw physical reactions. I saw head movements, eye closure, shaking, like involuntary, like not things that you do on purpose to make it seem like you're sad or having a reaction, or things that you don't do consciously, things that happen when you're being triggered. So yeah, she's not my favorite. Not at all. And the way, I will never forget. I'm so shocked by it. And I know you're probably sick of hearing me say it, because I've said it every time I've done a video on the woman. The way she was like bullying her and in front of her. What did he do? What did he do? Like, that was uncalled for. That was just uncalled for. But yeah, Leslie Abramson was aggressive, but she didn't come off as a bully. You can be aggressive without coming off like you're just... You can be strong and aggressive and a zealous advocate without coming across as somebody that's not listening and not paying attention to what you're saying. Like, they just came across as, we don't care what anybody says. This is what we think, and that's it. It's like Leslie Abramson, like, you could tell, like, she was listening to the witnesses, and like the next question she asks pertained to what they just said. Like, she was paying attention. She didn't have she had an agenda, but you couldn't tell that by the way she was acting. She was listening. That though they just ran over her. And then in closing arguments, it was manipulator. I forgot how many times. And like I keep saying, it might have started out that way. She might have been trying to get sole custody and whatever, or fake him out. I don't know. But look at it this way. If none of that had happened, if they had just been estranged and they had the custody issue, it hadn't been like a bitter custody battle. If they had been co-parenting like normal, exes that cared more about their child than themselves, and they had an amicable breakup, and they co-parented like normal people. And then that night happened the same way that it happened, and she felt in fear for her life. Do you think that she would be in jail right now? I don't think so. I think she would have been able to say that she was in fear for her life that night, and that people would have believed her. But because of the bad custody thing with the kid, they don't believe her because they think that she killed him so she got custody of the child. If there was no child involved and he did all the stuff that he did, where did they live before? Maryland? Or I don't remember. Wherever they lived before. If he did all that stuff and then she came to Florida and he followed her to Florida, and they didn't have a kid, and she took out a TPO against him and all that stuff, and that happened, do you think she would be in jail right now? No. So I don't know why it makes a difference, because they had a kid and they had a bad custody battle going on. So I don't know. I went on the jury. So there's a notice of appearance. So I guess they did get her. Well, where did it go? Dang it. Oh, that's right. I accidentally opened up another window. Notice of appearance on behalf comes now Brett McIntosh, PA, and files this notice of appearance on behalf of juror Sarah Walcott in the post-conviction proceedings of this case. Brett McIntosh. So which one? Kevin M. Griffith or Brett McIntosh? I guess Brett McIntosh. Yeah, files this notice of appearance. Okay, so I guess that's her. That's that juror's new attorney. There's the 6 notices to appear. And there's the October 4th, 9 a.m., 2 hours. It says in camera somewhere. Right there. To be conducted in camera. Yeah, I'm bummed, but it's okay. At least we got to see this. Because I didn't think we were going to get to see this. Well, I was going to get to see it. Well, it's just their first names. Their last name is just the initial. No, it's still scheduled for the October 22nd. So I will be live streaming that too. Hopefully Sarah Boone's trial will be over. I guess I can always do the sentencing later in the day after, because I can't see my calendar from here. Because now Owens wants... Okay, so they made Sarah's trial 3 weeks long when she was defending herself. Now that she's not defending herself, he moved it back to 2 weeks. But now because the judge thinks that it might be as long as maybe 3 days to pick a jury, now Owens wants it to be 3 weeks again. So, yeah. So 3 weeks will mean that her trial and Ashley's sentencing will overlap. Well, I'll work it out somehow. And I also learned a valuable lesson today. I'm not ever going to Google anything that you tell me again while I'm live streaming. Now I have to go back and watch so I can see my reaction when I read that. Now I got to do a deep dive on that guy. I cannot believe Todd is the expert witness. Oh, gosh. I can't believe the expert witness in her case was arrested in 2012 for storing body parts. He got fined. I forgot how much for inappropriate disposal of hazardous waste. Why does a medical examiner? What is that for, like stuff that I know you never said when? You did. You said look it up sometime. That was my fault. I learned my lesson though. Is that like people that aren't claimed or something? The medical examiner has to. Okay, this is getting morbid. All right. Thanks for hanging out with me, Flash. And thank you to Replay Crew. I hope y'all enjoyed it. I'm glad that I finally got to see it because I know I was very bummed out when it wasn't live streamed. And I hate that we don't get to see the interviews, but hopefully we'll get to at least know the outcome. And I hope she gets a new trial because, and hopefully with different prosecutors this time if she does. Yeah. Yeah, he's like a crime scene reconstructionist. But I don't think, I mean, he's for the defense. And I always say like experts get paid, but they don't get paid just to say what the side they're getting paid by wants them to say. Like if their expert opinion differs, they pass. They don't do it. But there's no way he can say it happened the way she says it happened. Maybe he is just going to say, because he sounds like a POS, so maybe he is just going to say what they pay him to say. What it sounds like to me. Now that I know the kind of person, because, I mean, that explains why he's not a medical examiner anymore, I guess. Oh, and speaking of, like, how we know? I didn't even think about this until I think it was Suzanne O'Donnell that brought it up. We don't know if, okay, let's say that guy was the brother of a juror. We don't know if he texted anything back. He could have. And if it was in Law and Crime's chat feed, we always know more than the jury, right? So if he texted something back to her and she told the jurors, it could have been information. Because remember, I was like, well, a flip phone doesn't get internet access. But he could have told her something they weren't supposed to know. I didn't even think about that until Suzanne brought that up, which is a good point. Against her interest. Because if he did tell her something and she told the jurors and it was something they weren't supposed to know, there you go. So, okay, well, so let's see. I was going to say October 4th, but no, we won't be able to see that one. So October 7th. Well, no, I don't know what I'm going to do because I don't remember with Ashley's trial how I did jury selection. Because I didn't do anything until the opening You know what? I think I was waiting for. That's what it was. Alita was going to do it, and she decided at the last minute she wasn't going to do it. So jury selection had already been done and over with. So I guess I'm just going to keep an eye on it. So I know I won't be live streaming on the 7th. So I guess I'll be ready to go on the 8th, but I guess I'll make a community post or something. I'll keep an eye. I'll just keep checking on the 7th and see. Oh, that's right. That's right. Okay. 26th. I knew there was another date coming up before the 7th. 26th is a pretrial hearing. Yeah, I have that in my calendar too. Okay. So the 26th. I knew there was another date before then. 26th. And I am working on another video, but I have to watch a movie and a Netflix special first before I can finish it. I'm doing the Devil Made Me Do It case. That's going to be my Halloween episode this year. And I don't know if I'm going to do it before Halloween or after because of the trial. So it's going to be soon. I'm going to smush it in somewhere. So, forgot the last name. I don't think it's Murdaugh. Was it Murdaugh? I took notes on it. I was like reading and watching and all kinds of stuff. And I also was going to do a deep dive on the Warrens too. And not now. I got too much other stuff going on now. But like it would be like a deep dive. What? This one was a Florida? I've not heard of that one then. The Devil Made Me Do It was. See, all this trial stuff, and I started researching this one the other day, and now it's just gone. That's why I need to watch the movie and the next flip, because the Netflix special, the kid that was possessed, his brothers are on it, and one of them says that it was because their mother dosed them with Sominex every night. And that has Benadryl in it, and Benadryl in high doses can cause hallucinations and stuff. And his brother thinks that he just was getting too high of a dose of Benadryl. And now there's this TikTok challenge where you take a whole bunch of Benadryl and you get high off of it and have hallucinations and stuff, and kids are ended up in the hospital. So that's why I want to watch the Netflix special. And of course, the movie is the fictionized version, so it has stuff in it that didn't actually happen. And no, that's not David Berkowitz. That's no, it's not Son of Sam. It's dang, I can't remember what state it was. It was a boy who his older sister was engaged to be married, and they rented a house. And supposedly there was an evil spirit in the house, and it possessed her little brother. They went over there, like they had rented it, but it had to be like cleaned up. And they went over there to clean up one day, and they lived at her mom's house. So they went over there to clean up. He got possessed or whatever. And then they went back to their mom's house, and at first the spirit or whatever just followed them home, and then he refused to go back to the rental house. You don't know this one? I'm surprised. Oh my gosh, I can't believe I found a case you've never heard of. So and like I said, I don't remember all the specifics right now off the top of my head, but so you'll have to watch the video if I ever got it finished. So they decided they weren't gonna take the house because of the ghost or spirit or whatever. And the boy was having like seizures and seeing stuff and all the typical possession things. And they had an exorcism, several exorcisms done. They had the house blessed and all that stuff. And during one of the exorcisms, the sister's fiance said, "Leave him alone. Why don't you mess with somebody else? Leave him alone and come to me. Come mess with me." And supposedly the spirit left the boy and went into him. And then no, it's not the Amityville Horror. It's the people, some of the people that were involved in the Amityville Horror, the Warrens, what were their names? The Conjuring, the people that did The Conjuring are the people that did this one too. And A Haunting in Connecticut. They did a whole bunch. There's like a whole series of horror movies based on this couple that went around and like helped all these families that had haunted houses. So in the movie, if you watch the movie, which is the fictionalized version, it makes it sound like he did it like the next day, but it was months later. He killed his landlord. And like I said, they make it seem like he got possessed by that spirit and like the next day or a couple days later that he killed his landlord. It was like months later. And they used that defense in court that he was possessed. Well, they tried to use it. And they make it seem like if you look up the case now, even on Wikipedia, it says it's the first court case to ever use that defense, but they didn't use that defense because the judge threw it out. The judge wouldn't let them use that defense. There's no scientific basis. You can't prove somebody was possessed by the devil when they killed somebody. So, but he ended up, I think he got charged with manslaughter, and he only got, I forgot how much time he was supposed to serve, but he got out for good behavior and he only served 5 years. And the girlfriend, they got married in prison. Like his last year in prison, they got married in prison. And she died in, I don't remember. I want to say 2014. And they were married. They stayed married until her death. I don't know how she died. But so yeah, he just got off manslaughter. When they moved out of her mom's house, she was a dog groomer, and the guy that she worked for at the kennel where the dogs were, there was like an apartment or something that he rented to them. And she was working at the kennels one day, and for some reason, his name was Arnie. I don't remember his last name. He, for some reason, didn't go to work that day, and his sister and her little cousin were there, and she took, and the landlord, which was her boss at the kennel. How did you find that? Is that his name? I gotta get my notes. I'm all over the place. Her name was Debbie. I should have remembered that, huh? Arnie Cheyenne Johnson. And the guy he killed, his name was Alan Bono. And the show on Netflix is called The Devil on Trial. And there's an episode. Okay, you know that show, A Haunting? They're on A Haunting, and the episode is called Where Demons Dwell. And I watched that show, and it doesn't mention anything at all about him killing the guy or being in jail. It's just the part about the ghost or the spirit or whatever. So, yeah, it's a pretty weird story. But if you watch A Haunting, you don't get the part about the murder at all. So, but I'm anxious to watch the Netflix special because I want to know the part about, like, why did their mom drug them with Sominex every night? That's weird. But, yeah. So, and the Warrens, they were like this demonologist couple that would, like, go around and, you're still here. Why does it say nobody's watching? They would go around and help people that had, like, hauntings and possessions and stuff. But there's, like, there's evidence that they were fake, and there's also evidence that they weren't. So, like, I want to, like, do a deep dive into them and, like, look at both sides just because I'm curious. I've seen videos. Usually you don't see everything in the same video, but I've seen videos that are, you know, people they've helped and things they've done, and then this is why they're charlatans, and they, you know, they do things to get famous or take people's money or whatever, you know. So, which they didn't ever charge anybody, but they made money. Like, they made money off of this case because they hired a guy to write a book, and they told the people that, actually, they told the little boy that was possessed, they told him that he would be a rich little boy because they would write this book and it would scare people and they would make lots of money. And they made like $84,000 off the book, and I think the family got like $4,000 or something like that from it. So, yeah, Monster. What's Monster? Monster? I don't know that show. Oh, Dahmer. Wait. I didn't see that. I was afraid to watch. So so season 2 is, season 2 is about the Menendez brothers, and Javier Bardem is playing Jose. Oh, I gotta watch that. I just got Netflix back. I had canceled it because I wasn't watching it, but I just got it back so that I could watch that. Oh, I gotta watch that too. I guess I'm gonna watch Dauber. I didn't watch it because everybody was saying how mad everybody was about it because the family was upset because they, you know, and I get it. Like, I get it because you know how I am about the Gainesville Ripper, you know, like, people talk about them and there's no emotional connection and they just talk and talk and talk, and, you know, I either get mad and yell and blow your eardrums out or cry, you know? So, because I have that emotional connection to it, whereas, you know, people that didn't live through those things just talk about it. Yeah. No, I'll watch Dahmer. It's just that it was so controversial when it came out because everybody was like up in arms about it. You just don't understand, the victims don't want to see that or hear that, or, or his family doesn't want to see that or hear that. And not, it's true. I get it. And I was telling somebody the other day, it's like, I don't know why I'm fascinated by this stuff. I almost feel bad about myself because I am fascinated with this stuff, but you can't help what you're interested in, you just are. Okay, well, I'm going to go because I think my husband's fixing to start watching a ball game. And when he does that, he yells a lot. Why? You didn't like it or you couldn't handle it? I don't know. You know how I am about, like, I don't like cannibal stuff. So that's the one thing that I can handle pretty much any other type of thing that these crazy people do. I mean, not like, I don't like it. I don't like any of it. It all repulses me, but that repulses me the most, to the point that, like, I don't want to know anything about it at all. That's just unnatural. That's disgusting. That's ugh. Okay, well, I'll let you go. And thank you to all my other viewers and my replay crew. And thank you for being here. I'm glad we finally got to see it. And I'm glad that it had the outcome that we wanted. I don't know that the hearing of the jurors will have, the interview of the jurors will have the outcome that we want. But I feel so sorry for her. Because I feel like at that moment she was in fear for her life, and I don't think she should be in jail. But okay. Bye, guys. Mwah, I love y'all. Appreciate you too. Bye.